This morning at 10:03 a.m. Eastern Time, the Supreme Court ended this case's final escape route. 2 words did it. Application denied, 9 justices, 0 dissents, no explanation, no opinion. Most people think Supreme Court orders come with drama. This one came with silence, and that silence matters more, because this order landed exactly 72 hours after a critical legal filing most people missed, a filing that changed everything. On Monday afternoon, Melania Trump's legal team submitted a proffer agreement to federal prosecutors. That document outlines evidence she is prepared to provide in exchange for immunity consideration, 2 seismic legal events separated by exactly 72 hours. That timing is not accidental. Before anyone dismisses this as speculation or tabloid noise, let's ground this in verifiable facts. Court filings, public records, Supreme Court dockets, no anonymous sources, no unnamed insiders. We'll come back to what's inside that proffer agreement in a moment, because that's where the real story lives. First, you need to understand what just became legally binding. Melania Trump voluntarily waived spousal privilege. That is not symbolic. That is structural. Spousal privilege normally prevents prosecutors from compelling testimony between married partners. But the law is clear. The privilege belongs to the witness, not the defendant. And when it's waived voluntarily, courts cannot block it. The Supreme Court just confirmed that reality without debate. The evidence outlined in the proffer falls into 3 categories: financial documents, communications, witness corroboration. Together, they form a pattern federal prosecutors look for in white-collar cases. And now, there are no more appeals, no more procedural delays, no more emergency motions. The grand jury can hear this testimony within days. That matters because another clock is already ticking. A high-profile confirmation hearing is scheduled in early March, 6 weeks from now. The sequence of events tells you this wasn't spontaneous. It was anticipatory. Let me walk you through the last 72 hours, step by step, because the order matters. Monday afternoon, 2:00 p.m. Eastern, her attorney files a proffer agreement with the special counsel's office. In plain English, a proffer is a preview. The witness explains what they know, what they can testify to, what evidence they can provide. In exchange, prosecutors consider immunity. This happens frequently in federal cases. What makes this different is the identity of the witness and the scope of evidence. 24 hours later, Tuesday afternoon, another filing appears. The defendant's legal team submits an emergency appeal to the United States Supreme Court. Not a lower court, not an intermediate review, straight to the highest court in the country. They ask the court to block the testimony before the grand jury hears it. That speed matters. Emergency appeals usually take weeks to prepare. This one appeared in 24 hours. That suggests preparation, not reaction. While mainstream coverage framed this as desperation, the filings suggest anticipation. Wednesday morning, hour 48. The Supreme Court dockets the appeal. It assigns a case number, schedules it for review, but it does not issue a stay. A stay would have paused everything. No testimony, no movement. Silence instead. In Supreme Court practice, silence is informative. When justices see merit, they act quickly. When they don't, they let the process continue. Thursday morning, hour 72. 10:03 a.m. Eastern Time. One sentence appears on the docket. Application denied. No dissents, no concurring opinions. Even justices appointed by the defendant decline to object. When the court doesn't explain itself, it's because the law already did. That level of unanimity signals something specific. The legal argument did not warrant discussion. Now let's talk about what's actually inside that proffer agreement, because the headlines undersell its significance. The first category is financial documentation. Joint tax returns signed between 2014 and 2020. 6 consecutive years. Joint returns mean joint responsibility. Both sign under penalty of perjury. Those returns rely on asset valuations, property values, income representations, deductions. If assets were inflated to banks and deflated to tax authorities, prosecutors view that as dual exposure. According to filings, she was present during meetings with accountants where valuations were discussed. She asked questions. She sought clarification. Those interactions are documented in emails, now accessible to prosecutors. The second category involves communications. Text messages discussing property values ahead of lender meetings, emails with accountants referencing discrepancies, and recorded phone conversations. Yes, recorded. If recordings comply with consent laws, they are admissible. If they're included in a proffer, authenticity has already been vetted. This is where most defenses begin to collapse, because documents don't forget. The third category is corroboration. She can confirm testimony already given by bankers, by accountants, by appraisers. Federal prosecutors prize corroboration. One witness raises suspicion. Multiple witnesses establish pattern. Documents turn patterns into cases. Now comes the legal earthquake buried in this agreement. She waived spousal privilege explicitly, not under subpoena, not under threat, voluntarily. The agreement includes clear language waiving privilege for all covered matters. This matters because spousal privilege cannot be overridden by courts, but it can be surrendered by choice. We've seen this before. Mob cases, corporate fraud. Spouses cooperate when joint exposure becomes unavoidable. But this has never occurred at this level of power. This is not about marriage, it's about liability. Now let's address why the Supreme Court rejected the appeal so decisively. The defense raised 3 arguments. Each failed under existing precedent. First, they argued spousal testimony violates marital privacy protections. That argument fails under Trammell v. United States, decided in 1980. The court ruled the privilege belongs to the witness spouse, not the defendant. That precedent remains untouched. Second, they argued coercion. But the filing includes an affidavit stating her attorney initiated contact. No subpoena, no threats. Federal courts use a simple test for voluntariness. Who initiated contact? Was pressure applied? Here, the answers are documented. Third, they argued dangerous precedent, but precedent already exists. The court does not create exceptions based on identity. The appeal asked the court to bend the law. The court declined. Emergency appeals require 2 things: irreparable harm, likelihood of success. This appeal showed neither. Testimony is not irreparable harm, and overturning Trammell was never realistic. So the court moved on. Now let's talk about what happens next, because the timeline just accelerated. The grand jury meets twice weekly, Tuesday and Thursday. With no stay in place, testimony can occur immediately. Based on standard practice, this could happen within 7 days. After testimony, prosecutors face a decision. Option 1 is reinforcement. Use testimony to strengthen existing charges. Option 2 is expansion. Seek a superseding indictment. Here's what I'm watching. The proffer references a March 2020 phone call involving loan discussions. If false statements were coordinated, that raises conspiracy exposure. Conspiracy is a separate charge. It carries independent penalties. Agreement plus overt act equals conspiracy. This is where cases quietly grow teeth. The trial date currently stands at September 16th, 28 weeks away. With appeals exhausted, that date holds. No more delay strategies remain. Now let's step back and ask why this matters beyond one courtroom. This case sets 3 long-term precedents. First, spousal cooperation at the highest levels of power. Future prosecutors will remember this. Second, Supreme Court intolerance for privilege-based delay tactics. This order sends a signal. Third, equal application of accountability. For decades, wealth purchased time. Time purchased outcomes. Here, time ran out. Institutions held because the law was applied evenly. Finally, here's what I'm tracking over the next 30 days. Grand jury activity, defense motions, final immunity terms. Each will reveal strategy. Defense motions reveal fear. Prosecutorial silence reveals confidence. When immunity terms become public, the scope will be clear. The court didn't explain itself because it didn't need to. Spousal privilege can be waived. Evidence will be heard. No one is above the law, not wealth, not office, not proximity to power. And this case just crossed the point where control quietly transfers from defense to prosecution.